Now, the National Prosecuting Authority will challenge the discharge of the 24.9 million rand Nulane investment. The outcome of the case drew widespread criticism of the NPA and the Investigating Directorate, but the Prosecuting Authority believes the judge made errors in law and in fact. Let's discuss this now with Luthando Vilakazi, who is a lawyer at Open Secrets. Luthando, thank you for making time for us. A comedy of errors is how the acting Bloemfontein High Court judge described this NPA's case. It was really embarrassing and humiliating for that institution. The NPA now, in its appeal attempt, wants to argue that the judge made a litany of errors. What exactly are they arguing?
Hi, Clement. Thanks for having me. Yeah, I mean, it's been a dramatic case from the very inception up until this point. The grounds of appeal that the NPA are arguing are firstly that the judge misinterpreted the discharge section of the Criminal Procedure Act, Section 174. And that is the section that essentially outlines that if the prosecution has failed to lay forward any evidence relating to the offences committed by the accused, then the court is then allowed to discharge the accused. The other point of attack is that the common purpose principle was misinterpreted by acting Judge Gusha, and they say that she applied the test improperly. And then the last, or one of the few sort of points of attack is the way in which evidence was managed by the judge and the way in which she applied admissibility and the way in which she saw some evidence to be verifiable, but applied seemingly confusing principles in not allowing other evidence to be included.
Yeah, and of course, the judge was quite scathing on that issue of evidence, and she said, and I'll quote here, she said, the state failed to pass even the barest of threshold prima facie proof. Basically, what she was saying is, you failed to produce enough evidence to show the Gupta family and their associates were implicated in this fraud and money laundering case. So if the NPA succeeds in this bid to appeal, what would it need to do differently to convince the court? Because to say to the court, this is a strong case, because clearly from what the acting judge has said, the quality of the work that was done before the matter was placed before the court is quite lackluster.
Yes, there's a number of things that one also has to remember before we think about what the NPA should have done, right? We need to remember that this is the first state capture case that's being brought before our courts. And the precedents that are set here can have resounding consequences for other state capture cases that the NPA will be bringing. So the manner in which it brings a case also requires that the utmost care is given by the prosecutors and that the right people are there handling the case. Experienced prosecutors are being called to make arguments, and that evidence and the chain of evidence is being managed in a way that is admissible by courts. So if it was to be successful in actually going forward with the appeal, the NPA would really need to ensure that the precedent that it sets now is something that it can rely on in its other state capture cases. And particularly because of the fact that, this case is kind of a very, it's an example of how state capture functions in South Africa. It's the blueprint of money laundering between South Africa, between the UAE, between other, shell companies, corporations and corporate structures. That machinery is very well oiled.
Apologies there for cutting you earlier. Thank you so much for staying with us. You were explaining to us what the consequences will be, and you can continue with that point, because if the NPA fails in their bid to appeal, there are going to be consequences, bearing in mind, as you've already alluded, this is the first state capture case, and the very same case we're trying to use to bring the Guptas back here.
Yes, not a problem. Thanks, Clement. Yeah, so the significance of this appeal is really important, and I think one of the things the NPA can do is to, do what it can to ensure that the best people are assigned to this case. One of the things I'm aware of is that advocates Du Plessis and Andrea Johnson and Shamila Batowi have all been sort of very concerned with the fact that the Investigative Directorate has not been made permanent through legislation. And that was something that was promised, I think, 7, 8 odd months ago. Yeah. And that is the reason, according to them, that prevents them from hiring very skilled and experienced personnel who understand money laundering, illicit financial flows, analysts, the kind of people who can point to exactly how these kinds of corruption cases are played out and where the evidence is. So on the one hand, the NPA is saying that, it is limited in its resources and expertise. On the other hand, they're also asking us to have faith in them. So they're going to very much need to find some kind of balance. Both of those things can't be true. Either we have faith in you and you have the capabilities, or you do not have the capabilities, and we need to reassess how they ensure that they are capable.
Yeah, they've indicated that the outcome of this case, in fact, has no bearing on their ability to prosecute any other state capture cases. But the outcome of that Bloemfontein High Court Nulane case sure doesn't give us that much confidence. Wasn't there an announcement, Luthando, that the legal experts who worked with, or even the investigating officers who worked with the State Capture Commission, were going to be referred to the NPA to help them as they go through thousands and thousands of evidence that was delivered and worked on at the State Capture Inquiry? Surely that's going to assist in increasing that capacity and supplementing those skills that the NPA needs the most.
Yes, absolutely. And that is the kind of thing that needs to happen in order for the NPA to finally find its feet and be able to successfully prosecute cases. But the other thing that we need to bear in mind is if independent persons need to be appointed so often in order for it to be functional, we really do need to reassess what the NPA's position as a prosecuting authority is. And also, even in this case, the 24.9 million that is at stake is a small fraction of the extent of some of the corruption cases that we've seen. We know that up to 5 billion or 3.5 billion rand was looted through PRASA over a number of years during the 2 Tall Chains debacle. So if it cannot handle a case that is of even less than 1 billion, even where there is assistance, it's just, it's very hard to be optimistic.
Yeah. Luthando Vilakazi, a lawyer at Open Secrets, thank you for making time for us this afternoon.